the school year nears, many parents will soon be celebrating their children's graduation, while others will be helping their kids prepare for college or university in the fall. But what obligations do separated parents have to provide child support for children over 19? Joining us now is family lawyer Stuart Zukerman. Good morning, Stuart. Thanks for joining us.
Good morning. Thanks for having me.
It's an interesting subject. First of all, tell us, when does child support normally end?
Well, normally child support is payable until the child reaches the age of majority, which in BC is 19, unless by reason of illness, disability, or other cause, including full-time attendance at school, the child is unable to withdraw from dependence on a parent, in which case this child support can continue beyond 19. I've had cases where child support was payable for children in their 40s, like severely disabled adults, where they have separated parents. You can still seek support from one of the parents to the other to assist a disabled child.
So is there a final cutoff age, or, as you mentioned, child support can be ordered even when the child is, into mid to late 20s and beyond?
Well, it depends on a number of factors. Typically, child support will be ordered until the child attains their first degree or diploma if they're going for post-secondary education beyond 19. But there have been a number of cases where child support has been ordered for children in their late 20s, early 30s who are still pursuing a third or a second degree. There's a case from Ontario where a 31-year-old was pursuing a PhD, and the father had already paid child support through the undergraduate, through the Bachelor of Law degree, through the master's degree, and now the child at 31 was going for a PhD, and the court ordered the father to continue to pay support. In that particular case, both parents had PhDs and had encouraged the child to pursue a PhD while they were still a couple. So the court continued the pattern of education that existed before the separation.
Interesting. Okay, so what if the child refuses to communicate or maintain a civil relationship with a parent who's being asked to pay support?
So that's a big issue. I was a successful counsel in the leading case in Canada on that topic called Farden and Farden way back from 1993. It's been cited in over 1,500 cases since then, where the court agreed with my argument that the father in that case should not have to pay child support for a child who refused to provide information to show that they're successfully pursuing a course of study. The child wouldn't share what courses he was taking, what grades he was getting, and showing that those courses would lead to self-sufficiency, and where the child unilaterally refuses to communicate with a parent from whom they're seeking support. And the court set out a number of factors for judges to consider. They're called the Farden factors, and they include a consideration of the student's own income, hours of study per week, the ability of the student to obtain student loans or scholarships, academic performance, age, and plans made prior to separation, amongst other factors, to decide whether or not child support can continue for a child over 19 who's not communicating with their parent.
Okay, here's another scenario. What if a child starts working full time at, say, 19 or 20, so presumably no longer in need of the child support, then decides to go to university or college later in their 20s? Can a parent be ordered to resume child support at that later stage?
So yes, typically child support can, a child who ceases to be a child at 19 because they're not in school anymore, if they go back to school at 21, 22, or their mid-20s in order to become self-sufficient with a degree, typically child support can resume at that later date. I was involved in a case where a 21-year-old who had obviously graduated high school, got a job, but then lost his job due to committing a criminal offense, and then went back to school while living with and dependent on his mother. And in that case, the court ordered that the criminal, or found that the criminal conduct had been an adult decision, which ceased to be able to call the child a child of the marriage after that criminal conduct, and therefore child support was not reinstituted, despite the fact that the child was going back to school and living with his parents. So child support can be cut off depending on the conduct of the child.
Stuart, what should our viewers do if they have questions about their child support obligations?
Well, they should feel free to call my firm, Zukerman Law Group, or go to zukermanlaw.ca for a free, no obligation, completely confidential initial consultation. It can be done via phone, via Zoom, or otherwise, in order to answer all your family law questions. Don't rely on friends and family for legal advice. Speak to a lawyer.
Yeah, good advice. Okay, Stuart Zukerman, thanks for joining us this morning. Have a great day.
Thanks for having me. Bye-bye.